Good evening, everybody. We are very lucky. Peter Meier-Beck volunteered. Professor Meier-Beck of University College London volunteered to give this talk. I think I probably said yes within about 20 minutes, only because I didn't get the email. I didn't look at the email earlier. This is probably the first really big decision of the UPC. We all can have our take on it. I am not going to say what my take is, but it may have something to do with the European Patent Office's somewhat bizarre notion that a patent is not a legal document and consists of two quite distinct and different parts, a description and a set of claims, neither speaking to or even knowing about the other. So, Peter, what's your take?
Thank you. Thank you very much, Robin. I'm delighted to see Lord Hoffman in the audience. And on the other hand, I'm a bit worried about that. Please, Lenny, correct me if I should quote you incorrectly. When he gave a lecture in Germany many years ago, Lord Hoffman began as follows. In England, you start a speech with a joke. In Germany, you start with a Gliederung. He used the German word for outline. And then he said, having made my joke, here's my Gliederung. I thought about applying this to the situation of a German judge going to give a speech in London, but this would have meant a lengthy joke followed by an even lengthier Gliederung. So I came to the conclusion, forget both. I'm glad to have the opportunity to present you the decision of the UPC Court of Appeal in the 10x Genomics versus Nanostring case. As you know, the UPC started operations on 1st of June 2023, and approximately 9 months later, we have the second instance decision on of the new court, which deals in detail with the interpretation of an asserted patent claim. And the first decision of the Court of Appeal, which deals with the patentability of the subject matter of a European patent, of a European unitary patent, to put it more precisely, but that doesn't matter in the end. Very briefly, the history of the case. The Court of First Instance, Munich Local Division, found the patent valid and infringed and granted preliminary injunctive relief. The Court of Appeal overturned the first instance decision, and what is more important, it dismissed the application based on its own claim construction and its own assessment of patent validity. The structure, the Gliederung of the judgment is the following. The Court of Appeal briefly ruled that the appeal's objections to the jurisdiction of the local division and to the admissibility of the request for interim measures were unfounded. The court then turned without further ado to the patent in suit and its technical teaching. And this explanation of the invention, the underlying problem, and how it was solved was followed by a detailed construction of the asserted patent claim. Based on this claim construction, novelty was examined and affirmed, and finally, the Court of Appeal examined inventive step and affirmed obviousness of the invention, and that was the reason why the application was rejected. that is how it starts. The patent at issue relates to a method for detecting a plurality of analytes in a cell or tissue sample. According to the description of the patent at issue, there is a need for multiplexing techniques in biology. It's not necessary to understand each and every detail of the claim and the technical teaching, but I think it's useful to get at least a rough understanding of the subject matter of the patent claim. And what claim 1 says is there is a sample mounted on a solid support. That's evident. It's brought into contact with a composition comprising a plurality of detection reagents. They are defined in more detail. Don't worry about the details. The detection reagents consist of a plurality of subpopulations. Each of them targets a different analyte, and there are specific predetermined subsequences conjugated to these different subpopulations. Then the sample is incubated for a sufficient amount of time, that will play a role later on, sufficient amount of time to allow the detection reagents to bind to the analyte. And then we come closer to the point of the invention, to detect the subsequences in a temporally sequential manner. A set of decoder probes is hybridized, signal signature is detected, removed, and these steps are repeated using the temporal order of the signatures corresponding to the predetermined subsequences of the detection reagent to identify a subpopulation of the detection reagents. The idea is this use of different temporal sequences of signatures is intended to solve the problem addressed in the description. There is only a small number of different colors, sufficiently clearly distinguishable colors that are available for labeling. And by using different temporal orders of the signatures, you can have more distinctions than by the mere number of different colors, because you can combine the different colors in different orders, and so you get a higher number of distinguishable colors and color sequences. The Court of Appeal then says that Claim 1 of the patent requires interpretation with regard to some of its features. And the court explains how it will proceed, from which principles it will proceed to construe the claim in accordance with Article 69 EPC and the protocol on its interpretation. And after having explained these principles, I will come back to these principles immediately. After having explained these principles, the court says these principles for the interpretation of a patent claim apply equally to the assessment of the infringement and the validity of a European patent. Especially the last sentence is of enormous importance for the way the court proceeds. Claim construction. What does it mean? It means understanding the content and meaning of the patent claim as a whole, not interpreting a single feature and grasping the technical meaning of a feature in the patent claim, but understanding the claim as such, because it is this claim which determines the content and scope of the exclusive right assigned to the patentee for exclusive use, and this claim is enforceable against third parties. At the same time, it is the subject matter of that exclusive right, defined by the patent claim, which must be measured against the standard of prior art when novelty and inventive step are examined. And it must be measured against the standard of the application as filed when added matter is examined. The UPC Court of Appeal formulates this a bit differently, but states it, at least in my view, explicitly at the end of the short subsection of the reason where the court deals with this question. There it explains why the principles set out for the interpretation of a patent claim apply equally to the assessment of infringement and validity. The court says this follows from the function of the patent claims, which under the European Patent Convention serve to define the scope of protection of the patent under Article 69 EPC, and thus the rights of the patent proprietor in the designated contracting states under Article 64 EPC, taking into account the conditions for patentability under Article 52 to 57 EPC. See EPO Enlarged Board of Appeal G288. This sentence is taken almost verbatim from the EPA decision G288, more verbatim in the German version of the UPC judgment, which takes the text from the EPO decision. The English version of the UPC judgment is a translation from the German judgment, German version of the judgment, so it's not identical with the English text of the EPO Board of Appeal decision, but at least similar. This quote is surprising at first because the almost 35-year reception history of this decision has not prevented a passionate discussion in the case law of the technical boards of appeal about the condition under which the description may be used or must not be used to determine the subject matter of the patent claim. You may think that the EPO is only cited in order to get the EPO boards of appeal on board. But I think the citation is not arbitrarily chosen, nor does the Court of Appeal attribute any meaning to this citation that it does not have according to the context in which it appears. The Enlarged Board of Appeal, in fact, draws a line between Article 69 and Article 84 EPC and assigns to the patent claim the function of determining the subject matter to be examined for patentability. For this subject matter, if it passes this examination, the exclusive right is granted. And for this subject matter, the scope of protection extending beyond that subject matter and comprising equivalence, the scope of protection is to be determined in infringement proceedings. Otherwise, the subject matter of the exclusive right would, or at least could be different from what has been examined for patentability and may have to be re-examined in connection with an infringement dispute. The scope of protection for subject matter other than that protected by the patent grant leads the patent system ad absurdum. The UPC Court of Appeal rightly refers not to the examination of infringement and patentability, but to the examination of infringement and validity of a patent. as I've said, even if the question of added matter is to be examined, or the question of whether priority can be claimed, the subject matter of the examination is in any case one and the same subject matter of the patent claim. I think that the importance of this clarification can hardly be overestimated. The German dual track system, so-called bifurcated system, is often accused of fostering the so-called Angora cat phenomenon. But Angora cats are omnipresent. At present, the principles of claim construction, well known to the practitioner from UK or German court practice, are combined in the very same UPC proceedings. For instance, when presenting added matter or alleged added matter, are combined with EPO TBA decisions, which would accept little more than the wording of the text to be compared. So you have the Angora cat phenomenon in one and the same court proceedings, dealing with different questions, infringement on the one hand, and let's say added matter on the other hand. And I think it's a great advantage of the proceedings before the UPC that such a split consciousness, which only sees, so to speak, the other party's Angora cat, can be prevented by an initial claim construction step. If you construe the claim first and then examine infringement or examine added matter, then the Angora cat consequences may be excluded. At least I hope they can be excluded this way. What does claim construction mean in the view of the Court of Appeal? The patent, says the court, the patent claim is not only the starting point, but the decisive basis for determining the protected scope of a European patent. The interpretation of a patent claim does not depend solely on the strict literal meaning of the wording used. When the German and French language versions are quoted, or more precisely, the English and the French versions are quoted in the German language of the proceedings. Rather, the description and the drawings must always be used as explanatory aid for the interpretation of the patent claim, and not only to resolve any ambiguities in the patent claim. That is, of course, closely related to the wording of Article 1, Sentence 1 of the protocol on the interpretation. And the court goes on, however, this does not mean that the patent claim merely serves as a guideline and that its subject matter also extends to what, after examination of the description and drawings, appears to be the subject matter for which the patent proprietor seeks protection. This wording, based on the second sentence of Article 1 of the protocol, appears at first glance to be a somewhat bold analogy to the principles of determining the scope of protection, because this provision was intended to distinguish the determination of the scope of protection from an alleged earlier tendency in Germany to allow a very broad scope of protection that is more or less detached from the claim and derived solely from the description, so-called allgemeiner Erfindungsgedanke, general inventive concept. This is one of the extremes mentioned in the protocol, and it's contrast with the other extremes, supposedly English tendency to adhere strictly to the wording of the claim and not to allow any extension beyond the literal literal wording of the claim. Nevertheless, in my view, it makes sense to point out for the interpretation of the patent claim that the wording of the patent claim is not a mere guideline. Because the description must be used to construe the patent claim, of course, and this can lead to a different understanding than that conveyed by the wording of the patent claim in itself, even if the wording appears unambiguous. The ambiguity of the wording is not a prerequisite for interpretation, but can be its result. Only wording in which all aspects relevant to interpretation point in the same direction may be defined as unambiguous. In extreme cases, and only in extreme cases, the interpretation requirement can lead to the wording of the claim being turned into its opposite, and there's a famous German case deciding construing a claim in this way. However, if it is not possible to interpret the claim in a certain way, taking into account the context resulting from the description, it is the claim and not the description that is decisive for determining the subject matter of the patent. Because the use of the description is a consideration of the context in which the patent claim stands, no different from the consideration of the context of the patent claim when interpreting and understanding an individual feature of this claim, where such an interpretive context cannot be established. The wording of the claim must prevail. How is the claim of the patent in suit construed? The CFI's interpretation that a cell or tissue sample within the meaning of claim 1 is to be understood as a sample which is still structurally recognizable as a cell or tissue must be accepted. Must be accepted is a bit, in my view, a bit strange translation from the German version. What the court says is that it agrees with this understanding with CFI's interpretation of this feature. Such an understanding is supported by the wording of the claim, which distinguishes between the plurality of analytes to be detected and the cell or tissue sample, so that the two cannot be identical. Although the analytes are indeed part of the cell or tissue sample, the cell or tissue sample must be structurally recognizable as such. A short excursion on this interpretation of this feature. It would be beyond any doubt, in my view, if the cell or tissue structure were of relevance for the method according to the invention or the result of this method. But is this the case here? There is no indication in the patent claim that in addition to a temporal sequential assignment of signals to individual analytes, a spatial localization of the analytes in the sample should take place. The description, which only uses the term sample and not the term cell or tissue sample, which was added to the claim by the divisional application, or the second divisional, the divisional of the divisional, the description expressly states that a target molecule or analyte can be both part of a sample or its sole component. That is paragraph 211 of the description. If the claim appropriate addition cell or tissue is inserted at this point, the sentence reads as follows: a target molecule or an analyte can be part of a cell or tissue sample that contains other components, or can be the sole or major component of the sample. This point is not decisive for the outcome of the appeal judgment, but I mention it because it exemplifies the opposite poles of claim construction. On the one hand, there's a wording of the claim with the juxtaposition of cell and tissue sample on the one hand, and the analyte in such a sample on the other hand. It is quite clear that it's precisely the structure that distinguishes one from the other from a technical point of view. On the other hand, there's a context in which this terminology is used. That is a description which says that the analyte can be a component of the sample, but also the sole component of the sample, and does not deal with the spatial localization of the analyte in the sample. However this question may be decided, there is no patent remedy for resolving such a conflict, but everything can depend on the resolution of such a conflict. And the only thing that helps is claim construction, is a careful and complete analysis of all the details that can shed light on the correct understanding of the claim. Whilst the Court of Appeal agrees with the CFI in its understanding of the term cell or tissue sample, it contradicts the first instance in its incidental assumption that the detection reagents must remain bound to the respective analytes. This Court of Appeal agrees that the detection reagent must bind securely to the respective analytes, and in order to make this possible, a sufficient incubation time must be provided in accordance with feature 3. Contrary to the opinion of the CFI, however, the need for a sufficient incubation period does not preclude the decoder samples, once they have securely bound to the respective analytes, from being removed again at a later stage. For example, together with the removal of the signal signatures provided for in feature 4.3. You may remember they are removed and then bound again, and from being replaced again with the same detection reagent. So neither the wording of the patent claim nor the description, neither common general knowledge nor functional considerations provided any basis for the restrictive interpretation with which the CFI had justified the assumption of a further difference to prior art. That was the Angora cut again. This feature was used by the attacked embodiment, and it was a possibility to create a further differentiation to prior art. But as it couldn't be justified, as a Court of Appeal rightly said, and so construing the claim that way was excluded. Then the Court of Appeal continues with the examination of novelty. The court first rejects the argument that the article by Göransson and others, the document 6, was novelty destroying. This is a consequence of the interpretation of the term cell or tissue sample, because D6 analyze amplified single molecules, ASMs, and not cell and or tissue sample in the sense the Court of Appeal understood the claim. Nevertheless, because that was sufficient to say, to decide that the document was not novelty destroying, but nevertheless, the Court of Appeal describes the content of D6 in relative detail in order to conclude that all other features of Claim 1 were disclosed therein. this detailed explanation of the content of D6 lays a solid foundation for the subsequent discussion of inventive step. And I think what is even more important, the explanation is very welcome because it does not always happen in opposition and revocation proceedings, at least not in EPO proceedings and not in Germany. Rather, sentences and half sentences of a prior art document in which features of the invention according to the patent in suit are actually or allegedly disclosed are often selectively picked out, and these sentences may be scattered throughout the respective prior art document. This has 2 or 3 disadvantages. On the one hand, it does not really facilitate the understanding of the document by a non-technically trained judge. On the other hand, it has the disadvantage that the context of those relevant quotes in this prior art document may be lost. However, interpretation in context is just as important for prior art document as it is for the patent in suit, because the meaning of a word or phrase or paragraph of this prior art document may depend on this context. In addition, a piece of prior art may be read with the intention of not missing any feature of the patent claim that can be found there. And this can lead to a feature being found in a document that an unbiased reader would not have found there. The Bundesgerichtshof has called this a substitution of the context of the citation for the context of the later invention. And it is this later invention which determines what is sought in the prior art document. Finally, insufficient consideration of the context of a quotation can also lead to different technical facts being incorrectly derived from different terms. In this respect, too, a careful analysis of the overall disclosure of a piece of prior art as undertaken by the Court of Appeal can protect the practitioner from jumping to conclusions in one direction or the other when assessing novelty or inventive step. Since no other piece of prior art could be considered as novelty destroying, the Court of Appeal then turns to inventive step. The court does not identify a closest prior art in order to then derive the problem to be solved from the difference between the features of the patent and those of prior art. In EPO practice, it is this difference which is to be overcome by adding or modifying the distinguishing features. Instead, the Court of Appeal simply starts from the problem that it had taken from the patent in suit itself when construing the patent claim. This is neither to be understood as a general rejection of the problem solution approach as practiced by the Boards of Appeal, nor as a statement on the relevance of the problem formulated in the patent itself for the obviousness test. Both approaches can be useful in the examination of inventive step and lead to appropriate results. However, both approaches can also lead to artificial starting points for that examination and thus to inappropriate results. The affirmation or negation of inventive step depends solely on whether the technical teaching of the invention was obvious to a skilled person. Article 56 EPC does not require that the invention was obvious to a person skilled in the art who wanted to solve a particular technical problem caused by a particular piece of prior art. So it is irrelevant that it was not obvious to solve problem A by means of the invention if the same invention, the same technical teaching, was the obvious solution to problem B. since there was a need for multiplex analysis techniques, the skilled person had reason to consider whether the encoding and decoding method disclosed in D6, the document which was not novelty destroying, disclosed in D6 for ASMs arranged in vitro in an array format, could be transferred to the detection of ASMs in cell or tissue samples. The Court of Appeal additionally justifies the suggestion to think in this direction with a reference in D6 that rolling circle ASM have already been used for reading out various genotyping assays and for detecting proteins and protein complexes in situ, and with a similar reference in another piece of prior art. Since the patent in suit did not teach how the prior art method could be applied to a cell or tissue sample, but only that it was applied to them, the skilled person only had to answer the question whether such a transfer was reasonable and possible, or whether its realizability could at least be expected with a reasonable degree of certainty or probability. In such a situation, an inventive step could only have been assumed if the skilled person had reason to believe that the transfer of the disclosed in vitro method for ASMs to an in situ analysis would probably not be possible or could only be realized by overcoming considerable obstacles. That is, there would have been a lack of sufficient expectation of success for the attempted transfer. The lack of sufficient expectation of success is clearly denied by the Court of Appeal. The applicant's objection that there was no reasonable expectation of success from a technical point of view because they would have been confronted with problems such as molecular crowding, that is a difficulty of distinguishing between multiple analytes that occur in close proximity, molecular crowding or autofluorescence, that is that are unpredictable interactions between different analytes in the cell or tissue samples cannot be accepted either. Because, why? Because in the opinion of the Court of Appeal, adjudicating with two technically qualified judges, these are problems that regularly arise in connection with the in situ detection of analytes in tissue or cells samples, which a person skilled in the art would have been able to deal with on the basis of the expertise at the priority D. This assessment is supported by the fact that the patent at issue does not provide any information on how to deal with these aforementioned problems. I think that's long enough, even for a German speaker. Let me briefly summarize my impressions. The Court of Appeal's decision largely dispenses with abstract statements on claim interpretation and patentability examination. Instead, it proceeds in an admirably simply exemplary manner. However, this should not obscure the clear general statements that the judgment nevertheless indirectly contains. Without claiming to be exhaustive, I would like to summarize them in the following 7 commandments. First, always interpret the features of the claim in the context of that claim, and the claim in the context of the description, for whatever reason its subject matter interests you. Consider the usual technical understanding of a term, but do not jump to conclusions. Second, resist the inner Angora cat and and do not interpret the patent claim according to the consequences resulting from the understanding of a feature or the assumption of an implicit feature for validity or infringement. Third, also read each piece of prior art in its own context first. Resist the temptation to read into a document what you know from the patent in suit, but also do not jump to conclusions from different terms. 4, try to avoid an ex post view, but always be aware that you are necessarily an exposed viewer. 5th, carefully examine each piece of prior art put forward by the opponent to see whether it represents a plausible starting point from which the skilled person would have arrived at the invention in an obvious way. 6, remember that different problems to be solved can mean different paths with different hurdles to the same goal. And 7th and last point, argue with the concrete technical facts of the case and avoid buzzwords. Thank you very much.
Peter, I didn't ask you whether you would take questions. I assumed you would.
Yes, I'm happy.
Has anybody any questions or comments? Somebody must have a question or a comment.
Comments are
Darren.
great because I have not to answer them.
Thank you very much. I don't have any question on the question of claim construction because you covered that so thoroughly. But I wonder, could I step back to the question of whether in provisional proceedings the court should be considering infringement and validity in such detail at all? I mean, obviously, across Europe, there's a big difference in traditions where in the UK, as long as you've got an arguable case to be tried, it's all decided on the balance of harm. And the UPC has a balance of harm provision, which is mandatory to consider. This is all optional to consider, as the court may require the party to provide evidence. And it seems in these cases, the court has jumped in and said, we must require it. What do you think the court could do to have a dividing line between the cases where it does decide this and produces decisions which are 120 pages long and risk prejudging the case? Because how is the same panel going to go back and consider the merits of the case afresh?
Thank you. I'm aware of the fact that it comes as a surprise here in England how the Court of Appeal proceed in this case. It's less surprising for a German observer to see it done this way, but of course the difference is much bigger to what normally happens in English preliminary proceedings. I didn't cover this aspect of the decision because my topic was claim construction and examining validity, and so I was quite happy that the court did it the way it did it, and did not do it the other way, and consider and try to consider and balance the interests of the parties. I think in this case it was a possible way to decide the case because the Court of Appeal came to the conclusion it is highly probable that the claim will turn out to be invalid. That was enough to dismiss the application for interim measures and in injunctive relief. Of course, the court could have done it in a different way. I'm not sure that it will. The court of the UPC will always proceed in this way, but I think it's. I think my let's say, put it this way, my impression from the Court of Appeal decision is that it is probable that the examination on the merits, so to speak, will be the normal case, even in proceedings for provisional measures. I think that it's a bit. I think the English approach is closely related and connected with the trial, which takes place in proceedings on the merits to examine infringement and examine especially the validity of the patent in suit. And as this trial cannot take place in preliminary proceedings, it is necessary to limit for in my understanding, for English judge, it's necessary to limit him or herself to a balance of interest, and at least to a, if any assessment, a very provisional view on the substantive question. The German way to deal with this question is different, and the UPC's way to deal with this question may also be different. The court is expected to deal with these questions within 1 day, normally even in proceedings on the merits, and this means it has to be a quite focused analysis of the decisive questions. The questions that decide on infringement and on validity. It will be necessary to have a very front-loaded procedure, a detailed discussion of these questions before you open the oral hearing and then the trial on these questions, and that is what I expect to be. It was what the Court of Appeal. I didn't attend the oral hearing of the UPC, but I heard there was a quite long introduction by the presiding judge, President Klaus Grabinski. And he, as far as I know, he didn't give as the German judges like to do, a preliminary assessment of the relevant questions. The courts tend to think that feature A is realized, and the court is in doubt that feature B is realized, and the court tends to think that document D1 may be novelty destroying or maybe not, and that the decisive document is document 2 features and so on. He didn't say that, but at least he identified the relevant questions, so that the lawyers could focus their arguments on these points, and they could be very brief in relation to other aspects of the case. that facilitated the decision. Nevertheless, I too was a bit surprised. I could have imagined a Court of Appeal decision that simply said the decision, the analysis of the Court of First Instance is insufficient. We are not really satisfied with claim interpretation, and we are not really satisfied with the assessment of Inventive staff in relation to document, especially in relation to document D6. And because we are not satisfied with this analysis, we are reluctant to grant injunctive relief, and we have to balance the interests, and the result is injunctive relief. A preliminary injunctive relief is excluded because it's not insured. It's not insured that the patent is valid, but instead the court were very clear, saying not only that that validity was not insured, but on the contrary, it was in the court's view, it was highly probably that the claim will be invalidated. But another case may proceed in a different way. I think that can't be excluded.
I'm not sure I understand the procedure. This is an application for a preliminary injunction. And it was rejected on the grounds that the patent was probably obvious. Probably.
Yes, probably.
Now, when would it then be finally decided as to whether it was obvious? Did it contemplate there would be a further hearing for that purpose?
No, that was the end of the proceedings for preliminary injunctive relief.
The end of the preliminary proceedings.
Proceedings on the merits are pending.
They're
and
pending.
Will be decided.
So you could have a court come to a different view at some future date,
yeah,
and then there would be a final injunction granted or not, as the case may be. Well,
That is possibly. I can hardly imagine because the statement was quite clear, but it's of course that's possible. Yeah,
it's possible.
Yeah, it's possible.
And so at the moment, in the proceedings that we have been hearing about, presumably the question of whether damages would be an adequate remedy or the general sort of balance of convenience were not dealt with by the court because they were not argued, wasn't it? I mean, if these points had been raised by the lawyers, the Court of Appeal would have mentioned it, but they couldn't have been argued.
They were all argued in first instance proceedings because the Court of First Instance granted injunctive relief, so it had not only to decide on the validity but also on infringement and the balance of interest.
Yeah.
That is what they did, and it was you might say a quite harsh assessment of into the divergent interests of the parties, and as I say, what the Court of First Instance basically said was, it's highly probably that the patent is infringed. It's highly probably that the patent will turn out to be balance, and in this situation, considering the interests of the parties, speak in favor of injunctive relief, even without security. The Court of First Instance said no security necessary to secure the defendant against possible misassessment of infringement or validity.
Let's go now my own comment. 50 years ago was pre-cyanamide, and I'm old enough to remember those times. and getting interlocutory injunctions, preliminary injunctions. And basically, the merits really matter. Judge would look at the patent, look at the claim, look at, and Cyanamid happened. Lord knows how it went on. I wasn't involved in the case. It went on for weeks. It went on for 10 days in the Court of Appeal on 120 days at trial. But before then, basically, we were doing what this court has just done. I have another comment. It's actually, as the judge at first instance, there seemed to be some commercial matters going on which we didn't fully understand. But this appeared to be a bit of a dispute about what the rate of the license should be. It wasn't a real case about trying to exclude people.
I think the Epilady case went this way, that
And
we didn't agree on on equivalence, but it was an examination of detailed examination of at least claim construction and infringement.
I mean, looking at the judgment, of course, we haven't got the materials, but looking at the judgment, they said this was dead obvious. And I think an English judge might do exactly the same thing now, and I hope they will. Well, they're spending too much time on the balance of convenience. It's all turned into something rather different. And I would like to see that the English court might change its practice and look more at the merits and strength of the patent case. One judge once put it, well, actually, the important thing is the balance of injustice. I wonder where he is now. Any more?
I'll say something.
Yeah.
One consequence of the test we apply now in this country following Cyanamid is that if you've got a weak patent, the only way you're going to get something useful out of it is by applying for an interim injunction, because you suspect that when it comes to the hard examination at the trial, the patent will be revoked. Does this decision of the UPC rather suggest that policy of having a go, trying to keep the defendant out for a few months or years would be extremely unwise?
Yes, perhaps. Yes, I think you might say this case was a case with a quite weak patent, at least if you see if you trust in the reasons of the appeal judgment. It was a weak patent, and nevertheless it was taken from by the court of first instance as the basis for far-reaching preliminary injunction, and deciding that the interests of the patentee to enforce this patent way much more than the interests the interests of the defendant, and not to be forced to respect probably invalid patent. And I think because of this, because of the impression that the CFI's, the local Munich Local Division's judgment gave to the public, that it's possible to get injunctive relief even in preliminary injunction, and that the local division may be inclined to in case of doubt to decide that the patent will turn out to be valid. That, in contrast, was, I think, a strong incentive for the Court of Appeal to decide on the validity and to make clear that it is really important to first to construe the claim carefully and especially to consider prior art carefully and do not and you shouldn't and that you shouldn't trust too much in the examination by the European Patent Office, because in Germany that with this split competence to deal with infringement or with validity, that was sometimes the prevailing way to do it, just to say, oh, everything was considered by the EPO when the patent was granted. There is no new document. Every document was considered, and if there's a new document, it's not. It doesn't come closer to the patent in suit than the documents that were considered by the office. And because there's no document, no new document, the assumption is the patent will turn out to be valid. Period. And the different approaches at different places in Germany, sometimes more careful analysis of the merits of the validity case, sometimes a more formal approach, which more or less said if the EPO said the patent is good, we assume that it is really good. And I think what the Court of Appeal wanted to make clear is that is not enough.
And exactly interesting is that it may be the court has more confidence in the view of the patent's no good because it sat with two technical experts. And the two technical experts, if they both say, well, they're dead agreed, obviously they were, and they could explain terribly easy to the lawyer judge why this piece of prior art was so close and why there was absolutely no reason why what happened in that prior art, especially not only what it did, but what it's to do something else, they'll do it for everything. It's almost an old stainless steel case. You've got stainless steel comes out for one thing. There are lots of patents for doing lots of other things with stainless steel. And the court is wise. This court realized the patent offices do a good job, an extraordinarily good job, considering the time they get to do it in. But most of them are more a chunk with the figures on oppositions are 1/3 opposition succeeds entirely, 1/3 the claim is restricted, and 1/3 fail. And those are the cases that are opposed. And there may be other cases that are not opposed. So all patent agents never oppose a patent that's obvious, and they've got really good fight on it. Why bother?
I agree. That is a very important aspect, that we have a mixed bench of technically, legally and technically qualified judges. In the German proceedings, the infringement court said we do not know better whether the patent is valid because we have no technically qualified judges, and it's not our task to decide on validity. We decide only on infringement. And now we have a court that is competent to deal with both questions and is equipped with technically qualified judges. So the court cannot say we do not know better, that because it is its own task to decide, at least in the proceedings on the merits, whether the patent is valid or not. So I think the situation is quite different to...
This is not a court for patentees, it's a court for the patent system.
Yeah.
And I'm hearing that there are a lot of revocation cases started in the Central Division. because it's also a very good court for clearing out bad patterns quickly, as opposed to EPO oppositions. Where everybody's dead before they get the result.
Yeah.
Yes.
Following
The
on,
last one, probably. I don't-
thank you. Following on from the comments about the technical judges having and their role, what role do you see expert evidence having in terms of helping the court to construe a patent in the UPC?
Well, it's a bit difficult. I think it's a bit difficult to predict and perhaps too early, because we have only so far we have only seen proceedings for preliminary for provisional measures and proceedings on the merits, especially in complex cases, are still in a very early stadium. Nevertheless, my expectation would be that the role of experts, of party experts, as well as of possibly court-appointed expert, will be a much smaller one than in English proceedings. I think it will be more similar to EPO opposition proceedings, or also second instance revocation proceedings in Germany before the Bundesgerichtshof, where we used to have a court-appointed expert and then changed the law, and now in almost every case decide without having heard expert witnesses, which would be possible because it's a second instance full appeal court. But my experience says that in most cases, parties do not disagree on the technical content of the patent or a prior art document, but where they disagree is the interpretation, the understanding, claim construction, or conclusions to be drawn from certain statements in a prior art document. And in our view, most questions are legal questions, and my expectation is that will also influence the way the UPC will proceed, and the technical judges on the bench, I think, will support this way to deal with these questions, because it was always too surprising for me to say that the judges in the Court of First Instance in German revocation proceedings, the Federal Patent Court, where they had this mixed bench of technically and legally qualified benches, how reluctant they were to deal with expert opinions. My first idea was, oh, they are prepared to deal in detail with them because they know what they talk about, because they are technically qualified, but they didn't really like them. And the lawyers were very often to be able to plead before a bench without technically qualified judges, because we didn't pretend to know we didn't pretend to know better the technical effects of the case. We pretended to know better the legal consequences, of course, but not the understanding of the relevant technical aspects. I see only a smaller role of party experts in UPC proceedings, but that is, you know, a prognosis is a difficult thing, especially when it relates the future.
Thank you, Peter. Really enjoyed that.